I'm here with Central District California Bankruptcy Attorney of the Year, Erik Clark with Borowitz and Clark. Erik, how you doing?
I'm doing great, Phil. How are you doing today?
Doing fantastic. And you know what? To be named Bankruptcy Attorney of the Year, I've known you obviously for many years. And when I asked you, hey, why were you chosen? Right? I mean, I knew you did a lot for the Chapter 13 work and over the past couple of years. Then you started opening up about the homestead exemption in California and being very involved with the courts, right? And and really it just let's unpack this because this is something that I think the debtor bar doesn't realize on how they can give back to their local bar and really make an impact on debtors.
Yeah, I mean, I think that we have a really unique position and role to play in here because, judges, for the most part, are looking at debtors from the bench and see one side of the debtors and the debtor bar and trustees and all of the various players in the system. But we as bankruptcy lawyers get to see the process from a different view. And we get to see debtors from a different view. And there's sort of trials and tribulations the debtor attorneys go through that judges just don't know and don't have the background to truly understand in some cases. Not all, but in some cases, in many cases, I would say. And so we are able to bring our experience within the bankruptcy system and community to the court, whose job it is to write the rules and run the system and really have an impact on that. And I think it's one of the things one of the areas that debtor attorneys really don't take full advantage of is participating and talking and communicating with judges and trustees about the difficulties of what we do and also some of the maybe inefficiencies that we see or improvements that we see that could be made within the court system. Because at least in my experience, judges really want to hear where we can where we see improvements can be made. And then that does have an impact when they sit down to change the rules, change the processes. I mean, I remember the very beginning when I started sitting down with judges in a Chapter 13 bench bar committee that we created. And, we would talk to judges because in the central district, it's not like a lot of other districts around the country. The central district has 20 something judges on the regular. So there's just, there's a lot of different players and personalities at bay here. So what was surprising to me is how little each judge knew what the other judges did.
Yeah.
And so when you file the Chapter 13, and back then we had, most of them did Chapter 13s or heard Chapter 13 cases. Now in the LA district, at least, or division rather, there's only 4, but back then there was much more. But you had to plan a case not knowing which judge you were going to end up with. And it really created a problem on our part. So, just in the very early days of this bench bar committee, talking to judges about what kind of problem that created from a debtor's attorney's perspective to plan for what each contingency for what judge you got really opened their eyes to, whoa, wait a minute, maybe we need to sort of streamline some of the stuff. And that doesn't put the judge in a position where they have to give up their autonomy and their ability to run their courtroom as they see fit. But there's just a lot of little things that we were having to deal with in each courtroom that, if they were streamlined, made life a lot easier. And
For them too. I mean, for them too. I mean, the yeah, river. Yeah, I mean, everyone wins if we can figure out, the right pathway. And getting in on these committees and giving back the bar, it happened. But I mean, it's just not giving your time. Raising the homestead and raising Chapter 13, that turns into meaningful changes
sure,
for
sure, absolutely.
debtors and debtor attorney. Well, let's talk about the 13 to begin with, because it's the easiest. I mean, where was it and where did it go to? Like,
So I've actually been down that road 4 different times here in the Central District. When I started 20 years ago at DAP-CEPA, I believe, if I recall correctly, the Chapter 13 fees in the District were $2,500.
20
And so then BAT-CEPA came into play, and I sat down with one of the local staff attorneys for one of the Chapter 13 trustees, and we took it upon ourselves to start rewriting the rights and responsibilities agreement and some of the proposed rules and things in light of the changes that BAPSIPA were going to bring to
Right.
the system. And so during that process, there was this whole fear that bankruptcy was going to go away. And, we really didn't take the time to really read the rules and the new law carefully before it went into effect, because we were so inundated with clients banging down our doors at literally 10, 11 o'clock at night. So we were just trying to get through that. But then right afterwards, as we all can recall, there was sort of this nuclear winter of bankruptcy where there were no bankruptcies filed for about 8 months. And it gave us a really good opportunity to sort of start implementing and figuring out what this all meant. But what quickly became clear to me and a lot of other debtor attorneys was that this new process was going to require a lot of work. And so I then, with the help of some of the Chapter 13 trustees, presented to the Board of Judges meeting what that meant and what we were going to have to do to get the fees increased. So we've slowly gotten it increased. And so now, 20 years later, we're sitting here in the Central District. The fee is $7,000 for a non-business case, and $8,500 for a business case. And that, for the most part, takes you through the confirmation of the case. And then there's post-petition fees that we're able to charge, and for post-petition work that is necessary. And those are billed as supplemental fees throughout the course of the case. And so this last iteration of the increase, the judges recognized, with inflation, going crazy all over the country, that it was time to raise the fees. It had been a number of years. And so we raised the non-business case from 5,000 to 7,000, and the business case from 6,000 to 8,500. And then we got a corresponding 40% increase on all of our no-look supplemental fees for post-petition work, for those of us who do it on an.
Very, very meaningful work. I mean, very meaningful work, and it's a gift that keeps giving. And then not only that, it allows some debtors, more debtors to file because
Yeah, there's a number of reasons why. I mean, the real discussion with judges that I've had numerous times, and they get it here in the Central District, is that you've got to be able to keep good attorneys wanting to work in the bankruptcy space and being able to work in the bankruptcy space. And if you're not keeping your fees, at least at some base level, then those of us who do this need to go out and do some other area of law, and you lose that brain trust. And we already have a problem in the bankruptcy space right now where young attorneys are just not getting into bankruptcy
Yeah.
for whatever reason. And there's probably several reasons for that. But you can't be losing the people who are going to mentor the young attorneys because you're not allowing them to charge fees that are reasonable. So
Sadly, it's happening, and there's a lot of districts in the area who have the same cost of living as Central District, California, that are not at 7,000, 8,500, right? Because they're
yeah,
otherwise dead.
it's a combination. I mean, I've talked with a lot of attorneys around the country on this, and you've got to have those conversations, and you've got to open up the lines of communication with your trustees and your judges, and let them know why it's in their best interest to see these fees increased,
Yeah.
because you've got to keep good attorneys doing this work.
In the
So,
notes of this video, I'm gonna have a link to chapter13fee.com. It's a program that John Orkin and I put together. As you know, you're very familiar with it. It's on what John did, all the emails and all the written work and everything he did, his arguments on how he raised his fees, sort of like you did over the past 20 years. He just did it for the last 40 years, right?
yeah.
Um, Eric, tell me why. I mean, that's a big payoff. What advice would you give to a young debtor attorney or a debtor attorney that's not involved with their bar? What, just like speak into that a little bit, because I always wonder, why aren't people more involved? Why aren't more people putting their hat in the ring at NACBA, National Association of Consumer Bankruptcy Attorneys? There's all these things that we can do to shape law and shape the future of bankruptcy. And what are your thoughts on that?
Well, I think the vast majority of bankruptcy lawyers around the country are small or solo practitioners. And it is very easy to get completely consumed with the caseload. And it's emotionally draining. It takes up a lot of time. It doesn't end at 5 o'clock most days. And so it's really hard to find the time is the real answer, I think. Um, and also some of them may not understand the influence that they could have if they just stepped out into that space. I'm fortunate. I have a business partner. He and I have sort of had this agreement over the years that I would get out there and move the he sees the value in it just like I do to the community and to the firm. So we've carved out that time and made that time available to me to be able to get out there and do the things that I've been able to do. But it's difficult. It's difficult for somebody who's got a family and trying to run a business and has payroll and employees and all of that. And if you don't have a partner, it makes it much more difficult. If you don't have a business partner that can take some of that on themselves and free up some of your time to be able to, it makes it more difficult. So that's a big part of it. But I also think that there's just a part of it that they don't realize that they have the ability to make a difference. I mean, I talk to other attorneys around the country. I mean, I'm fortunate in the central district. There's a really good line of communication between the judges, the trustees, and the debtor bar. And a very powerful organization like the CDCBAA, the Central District Consumer Bankruptcy Attorney Association, that started 15 or so years ago and has been widely received and very well received by the bench and the trustees. And so there's a very good working relationship there. That doesn't exist, at least I hear around the country in every jurisdiction. But I think it's really incumbent upon debtor attorneys to do all that they can to try and create that communication and again start educating their trustees and their judges. I hear a lot about from around the country. It's a very adversarial relationship at the bar and the court and the trustees. And it's unfortunate because it really doesn't need to be that way. And it really doesn't help the system for it to be that way. Each one of us play a really important role in this process. And the more we get on the same page and share the way it works for us and the way it could be better, it's going to be better for everybody.
Eric, do trustees and judges want to hear from the debtor attorney? I mean, do they welcome it? Like I know you said adversarial. I've heard that same thing, but you seem to be reaching out. I mean, just I know
It's been my experience that most of them do. Most of the judges, not all. I mean, we're all human,
yeah,
and everybody's got their own issues. But for the most part, the judges really have been very receptive to what the debtor bar has to say. Again, here in the Central District, we have a very strong debtor bar organization led by very well respected attorneys. And so that has become the channel through most of this dialogue. But yeah, judges want to know what they're doing right. I mean, I literally have had judges pull me over in meeting, at seminars and say, "Hey, who are new, they've been only on the job for a few years, and ask me how they're doing. What could we be doing better? What could I be? How can I make my case?" I mean, they're dealing with huge caseloads.
yeah.
They're dealing with the same thing a lot of us are, where the work is just overwhelming. It's emotionally draining. It's physically draining. And so anything that we can do to help each other make our systems more efficient and better be able to handle the volume of what we're dealing with, that's just a win-win. And so, yeah, most of them see that.
Good. This is great information. Eric Clark, Borowitz and Clark, your referral source for California bankruptcies. Thank you for your time, Eric.
My pleasure. Thank you.